A very good morning, and this is Morning Express you're tuned into. It's time for us to go to the State of the Nation, and let me go straight to introducing my guests. And in my immediate left, I have Edwin Sifuna, who is an advocate, and welcome, Sifuna.
Thank you for
Good to have you. I hope the year has begun well.
Well, it has begun well.
Okay.
Can't complain.
All right. Any new appointment titles that you may have?
Well, we can talk about that when we finish.
As we continue with the debate. Okay, all right. And to my extreme left, we also have Maina, who's the Regional Director for Article 19. Gentlemen, thank you for joining us this morning. And this morning, I want us to look at mainly the state of the nation in regards to the Constitution. We do know that the CIC term ended recently, and the CIC had been given the mandate to midwife the Constitution and ensure within the 5 years we have at least most, or if not everything out of it put in place. Let me start with you, Maina, in regards to the fact that now CIC's term has expired and they're no longer there. Does that mean that the Constitution 2010 is now in jeopardy?
No, I don't think it would be a right conclusion to say that the Constitution is totally in jeopardy. The constitutional framers anticipated a transitional commission in the name of CIC, and it had certain fundamental roles to play, which in my judgment they did play that role. One was to understand how each of the executive arms that may generate initial policy or legal documents, what parameters they need to adhere to. But secondly was also to help Parliament in the discharge of their own functions to also begin to appreciate the limitations that have been put by the Constitution on the parliamentary powers to pass laws, because Parliament had earlier tended to regard itself as the ultimate body in passing laws without taking due regard to the Constitution. And three, it was to also help us develop a clearer calendar apart from the schedule, which talked about 5 years of implementation. It was supposed to come up with a roadmap on what other people would have called consequential laws, that without them, the implementation of the Constitution would not be well anchored. I think it is on the last part of their role that they didn't do very well, because they didn't talk about what are the other sets of laws that ought to be passed because of their nature, that they will influence or anchor all the other laws that were in the schedule. And I have in mind questions on issues of public participation, which we would be raising again, that that does not sit pretty with any of the government ministries or agencies. And such laws yet would be necessary to totally implement the law. So CIC, for me, failed by not prioritizing such a law, by not prioritizing, say, an access to information law, which such laws would have been able to totally, one, hold Parliament to account. For instance, we are now discussing these changes in the statutes, miscellaneous amendment laws, which have tended to be passed since time immemorial without any proper consultation. And we've seen this last change in the statute amendments law not clearly adhering to those principles of public participation. How are we going to bridge the gap? It's not like they didn't exist, so let's not say we would not miss them.
Maybe I'll pause you there a little bit and come to Edwin first of all, and just hear your take on CIC's performance and whether you feel that the Constitution would be at risk without the body that had been initially put there to ensure that the Constitution is implemented.
Well, I wouldn't say it's at risk. My brother has captured the situation very well. You should remember that under the Constitution itself, it is the responsibility of every single Kenyan to uphold and defend the Constitution. And the CIC, as he put it, was a transitional body to ensure that the laws that were required to operationalize this new document were put in place by the time their term expired. And the hue and cry from the fact that their term was not extended also has a relationship to the fact that the period within which those laws to operationalize the constitution was extended by a year by Parliament because they were unable to meet all the deadlines that had been set by the constitution. So for me, the performance of CIC has been, I would give them a B, because as my brother has said, the initial laws that required to be passed to implement the constitution, and we understand that they had a critical role to play because they were the first port of call together with the Law Reform Commission and the Kenya Law Reform Commission and the Office of the Attorney General whenever these pieces of legislation were passed. But on the other hand, we have seen certain issues arising because there were questions raised about, for instance, the stance taken by the chair of the CIC at certain points, where he seemed to be very friendly to the executive. And there's even talk that he's going to seek a political seat in Kisii in the forthcoming elections. And that had raised a few eyebrows, but I believe on the overall, we should do well. We should do well even without
all in all, you say they performed well. Of course, there's a lot more that they could have done by virtue of the fact you've given them a B and not an A.
Absolutely.
But at the same time, the Constitution is not at risk.
The Constitution can never be at risk because it wasn't only upon them to defend and uphold it. It is up to us as Kenyans to defend this document that we gave unto ourselves. And that is a role that has been placed upon us by the document itself, and we cannot abdicate it. So the fact that their term is over does not mean that it is at risk. Even when they were there, the document was always at risk, because the risk does not come from the absence of a CIC. It is the presence of people in power who do not believe in the document itself and what it espouses. So the greatest danger has never been from the absence of a commission or the absence of a defender. It is the presence of the danger is present in an executive that wants to define a greater role than that which it has been given in the Constitution.
Okay, we'll come to the executive and the legislature and how possibly they could, because the CIC chair is on record as saying we cannot entrust the executive, the legislature, the Senate to take care of the Constitution for us. We need to be active. But let me come to you, Henry Maina, in regards to now that we don't have the CIC, who is solely responsible to ensure that the Constitution, apart from now, the Mwananchi, of course, there are processes, but are there institutions and bodies that are in place to ensure that the Constitution is upheld?
One is to understand that the Constitution does not envisage a body. It envisages bodies. So we shouldn't try to put too much onto the doors of one agency. The Constitution, one, envisages that the executive in all its manifestations would live by constitutional principles, and by so doing it would be implementing the Constitution. It also envisages that the judiciary in all its manifestations would live by the principles and values as espoused by the Constitution, and same to Parliament. It also places an onerous responsibility on the constitutional commissions and independent offices. By that, you begin to see that our Constitution created an organic process through which, if any of these agencies fails to discharge its mandate as clearly delineated by the Constitution, then there would be checks. So the challenge we have as a country is, are those checks working? Are they going to work tomorrow without being watered down? And I think that's the challenge we need to speak to, that where we have a constitution and constitutional values, but most of our agencies do not live by them. Previously, I've coined a term called constituticide, which is the killing of the Constitution, because the older scholars had talked about constitutionalism, which they just thought it is that positive way of living those constitutional values. But there is a negative connotation to it, where there is an incessant zeal to negate the constitutional values. And I'm calling that constituticide, because it is a continuous process trying to reverse. It says you will follow this process, but we try to take a reverse. For me, that's the biggest challenge that exists. And this is not just a challenge to the executive, but also to the judiciary. Because the executive, in all its manifestations, would live by the principles and values as espoused by the Constitution, and same to Parliament. It also places an onerous responsibility on the constitutional commissions and independent offices. it is a challenge to Parliament, it is a challenge to the judiciary. That if we are not as vigilant, that's where citizens come in, that if we are not as vigilant, any of these bodies by themselves are not pious. They will not live by constitutional values. It is for the fear of sanctions, it is for the fear of discipline as put by the Constitution that we all live on the narrow line. If not, any of us can be rogue. So we just need to be reminded that, and we need to remind each other that that person who says go back to the narrow path is as patriotic as the person who is holding the office. Because we are in a country where anybody who points out a finger that you are off track is seen to be unpatriotic, is labeled, and like Sifuna, I don't subscribe to any of the political parties, but it is very easy for me to be pigeonholed into a political party if I disagree with any of those others. And the Constitution begins to tell us that that's not the marker of identity that we need to have. The marker that should identify us should be to what extent are we living, say, by Article 10, which has those values and principles.
Okay. Sifuna, let me come to you. And the Kenya Law Reforms Commission, is that a body that we should entrust and see at least, represent us in terms of having the Constitution implemented?
Well, like Henry said, it is not about a single institution to look after the tenets of the Constitution. It is up to all of these bodies. You will remember that whenever anyone is appointed to public office, they take an oath, and that oath is to defend the Constitution in the first place and to be a defender of law. So I do not think that the Kenya Law Reform Commission on its own would be in a position to safeguard the Constitution. And their role is also slightly limited to the extent that they are more involved in the legislative process, that they are one of the ports of call when a bill is presented, before a bill is presented to Parliament. They would be involved in the drafting of the laws and ensuring that it is compliant to the Constitution, together with the Office of AG and now the moribund CIC. So this has to be a collective effort, Mike. We cannot look for any single body. Yeah, absolutely. Yeah.
Okay. Maina, let's come to areas of concern. And we currently have one of the things that LSK has gone to court about, and that is in regards to the president being able to appoint the CJ, the DCJ, and the IG. Would that be viewed as retrogressive?
I think it is. Remember, I talked about constitutional values, and our Constitution was not made in a vacuum. It was made on the basis of a history that we had experienced over the years, because most of us tend to forget that the Constitution we changed in 2010, if you were to look at a version of the 1963 Constitution, some of the things we've put in the 2010 Constitution existed in 1963. But because they could be wished away at the whims of the president or the ruling elite, things went wrong. We therefore put safeguards and began to understand that, one, you do not hold public office at the behest of the president. That seemed to have been the rhetoric as the 1963 Constitution was mutilated. And we remember a time when we had a deputy police commissioner who was appointed to be the factory manager of Upland's factory. And he said, how can this happen? But the judgment in his case was that he holds office at the behest of the president.
Right.
We seem to have cured that by passing the Constitution, which dispersed those authorities and left the president with certain appointments to make for purposes of discharging executive functions. It's not like he was denied all appointments. But in the appointing of officers of the National Police Service, that was left to an independent body. Why? We wanted to professionalize the police service. We wanted to professionalize the defense forces. We wanted to professionalize the Kenya Prison Service. All this because previously they had been misused. The Statutes Miscellaneous Amendment Act 2014 seemed to have clawed away that independence and professionalization of the police and put them back into the challenge that they had. We had tenure of office clearly indicated. Yeah. We had the issue of gender representation, so that when the Inspector General is a man, the deputy must be a woman. We seem to be doing away with those values by saying, no, we just need to leave this to the president. And because he has gained courage after he did the first mutilation on the police, he has now moved to the judiciary. And here, I want to remind Kenyans that it is this very Jubilee government, when it was in court, as when the Security Laws Amendment Act was being challenged, that talked about the issue of separation of powers. The Jubilee lawyer, the Attorney General, the DPP, all based their argument on the principle of separation of powers.
Right.
It seems that all those arguments they made were void, because here we see a clear interference with the judiciary as an independent organ of government.
Okay.
And for me, that's a challenge, because the president still has a role. Even without changing this law, the president had a role of appointing. And in the event that the president had misgivings, whether he's given one name or three names as they are proposing, the president ought to have addressed the nation at that point of receiving the name and say, the person that has been proposed does not meet these constitutional values or thresholds, as opposed to the person I don't like. Because what we are doing is we're beginning to bring back patronage.
Right.
We are beginning to bring back sycophancy, so that people would be nominated on the basis their face is nice, their name could be likable, or as opposed to, do they have the gravitas to do the work?
Okay, Edwin Sifuna, your take on the fact that this could be retrogressive in terms of the spirit of the Constitution.
It is not that it could be, it is. Yes, and there's been quite some level of debate even amongst circles of lawyers on the implication of this new amendment. But as Henry said, one of the things that we should always remember is to contextualize why we arrived at a certain point, because there are certain experiences that we went through as a country, and we decided that there are things that we would want to leave behind, and there are things that we wanted to adopt as a norm in this country. For instance, if you look at the reports of the Constitution of Kenya Review Commission, and even the final report of a committee of experts on the judiciary, for instance, the overwhelming opinions of Kenyans as collected by the CKRC when it went round during the constitution making process, people expressed a very clear desire to have a judiciary that is independent in all ways from the executive. And one of those was to entrench the security of tenure of judges, and second of all was to completely remove the involvement of the executive in the appointment of judges. This body that we call the Judicial Service Commission, it never existed prior to the 2010 Constitution, and there is a reason why people wanted to give an independent body that can, absolutely, that mandate of picking judges.
Right.
And if you look at the problem becomes that constitution making is largely a give and take. And one of the greatest fallacies that we have, people imagine that the views of Kenyans, as raw as they were, would actually end up in the document that we call the Constitution. Yes, we pass this document as our own, but there is a level at which, a lot of trade is made. And I remember trying to find out the rationale that after Kenyans said clearly they did not want the involvement of the executive in the appointment of judges, how is it then that we came to a point where the text of the Constitution actually allowed the president, albeit in a ceremonial role, to be involved in the picking of judges, the appointment of judges, and the appointment of the Chief Justice and the Deputy Chief Justice? This was largely a trade-off of the political players in the country, that sometimes there is what we call separation anxiety, that we are so used to a certain way of life that a complete departure, a 90-degree or 180-degree turn from that particular position is very foreign, and people don't conceptualize it. And I remember coming across a text that says that it was just to placate the president, to be able to, you know, show him some level of respect, that yes, you can have a ceremonial role in the appointment of judges. But what experiences have we had with that ceremonial role? We see a position, a situation whereby the Judicial Service Commission, after going through the vetting and appointment of new judges, they send the names to the president, and the Constitution says he shall appoint them in accordance with the recommendations of the JSC. But the president sits on that list. You understand? So the greatest danger to the Constitution, actually, and especially with respect to the independence of the judiciary, has been an executive that is unwilling to admit that its role in the appointment of judges is purely ceremonial. Right. So we move from a certain position. And another example, if you want to know that the purest intentions of Kenyans would never have made it to the document itself, what were the views of Kenyans on an institution such as the provincial administration, for instance? If you ask many Kenyans, and if you read the report of the CKRC that went around the country collecting the views of Kenyans on what they wanted, Kenyans, out of the experiences they had with the provincial administration, and especially the chiefs, they were very categorical that this is an institution that needed to go. It needed to be disbanded. But because of the trade-offs at the political level, the political players in the country decided that this was too radical a departure, and that we needed somehow to retain the provincial administration and then try and see a way in which we can incorporate them into the devolved system. So we are at a stage where we need to ensure, because we have understood the kind of people we are not people who should be given any room to exercise any level of wiggle. Absolutely. And which is why my brother said he does not identify with any political cause. But this is why, for instance, the Okoa Kenya movement was born, because we realize that all the areas in the Constitution which have even wiggle room that depend largely on the goodwill of the people in power have to be squeezed out. So that absolutely, yes, so that when we say, for instance, in Article 10 that we should see diversity in the public service, and then we leave it to the goodwill of the people who appoint the public service, we end up with the situation in which we are today. So what do? It is as we need to tie their hands as much as possible so that we are able to see the fruits of the Constitution. So even this attempt to now alter the nature of the recommendation of the Judicial Service Commission is an affront on the independence of the JSC and the independence of the judiciary, which we as Kenyans should not allow. But we come to a final point of, I've been asking myself this question, and as a lawyer, as a member of the Law Society of Kenya, I am also enjoined under Section 4 of our constituting statute to be a guardian for the public in terms of constitutionality and the rule of law. But we also have institutions. The question you have kept asking us, what institution can we depend upon? For instance, right now we are hearing a lot of noise from the Law Society of Kenya, and it is one of those rare moments in the past 18 months that I actually agree with our chairman, which is something very rare.
I'll come to LSK in just a bit.
No, the point I wanted to make was this. We've been asking ourselves, as a member of a society, I take responsibility for the fact that we were not able to call this out when it was happening. And members of parliament, even the mover of the amendment himself, Mr. Samuel Chepkonga, is an advocate of the High Court, and is a member of the Law Society of Kenya. Members of the Legal Affairs Committee in Parliament, those are advocates. These are people who are enjoined under Section 4 of the Act to be able to be guardians of the Constitution and of the law.